worked hard, built a life, maybe bought a house, built a business, and stacked some savings. And now the marriage is ending. And suddenly it feels like everything you've worked for is up for grabs. Welcome to California's community property law, where unless you understand the rules, you could lose half of everything, even things you thought were yours. Hey, my name's Mark Reel Jr., the Fathers Rights Attorney, and today we are breaking down how property is divided in California divorce. This is not just about who keeps the couch or the car. This is about your home, your business, your retirement, and your future wealth. If you're a man going through divorce in Southern California and you're worried about losing what you've built, don't just wing it. Click the link in the description to schedule a free case evaluation with my team here at Real Fathers Rights. We've helped hundreds of men protect their assets, their rights, and their future. Let's dive in. First, what is community property? In California, we follow community property law, which means this: everything acquired during the marriage is presumed to be split 50-50. That includes income, real estate, retirement accounts, investments, businesses, cars, furniture, even credit card points. And yes, debt too. That's right. Your spouse's shopping spree or secret credit card could legally be your problem. Now, the community property clock starts ticking the day you get married. We call that the start of the marital economic community, and it stops the day you legally separate. That date of separation can become one of the most critical issues in your case. Why? Because everything earned after that point is considered separate again. What counts as separate property? So what doesn't get split? Here's what qualifies as separate property in general terms. Anything you owned before the marriage, bought a house, owned a car, that's going to be initially considered separate property. Inheritance or gifts you received during the marriage. If grandma passed away and left you some money, that could be your separate property. And anything you earned after the date of separation. Also, some personal injury awards are considered separate property. Sounds simple, right? Wrong. The line between separate property and community property can get blurry fast. Let's say you had a house before marriage, but you paid the mortgage with income earned during the marriage. Now that house might have a community interest. Or you started a business before marriage, but grew it during the marriage. Yeah, now you've got a mixed asset, and you may owe your ex part of that growth. What happens in divorce? When California divorce begins, both parties are required to make full financial disclosures. That includes bank statements, credit card balances, investment portfolios, property deeds, business interests, crypto and other digital assets, and retirement accounts. After those disclosures happen, that's when yourself and the opposing party will start discussing how to classify everything and what the split will be. You may determine some assets are community property to be divided, others are separate property that belongs to one spouse. But in absence of an agreement, the court will divide community property equally, 50-50. Now that doesn't mean you physically split the couch or cut the house in half. It means the value is split. So maybe one party keeps the house, the other keeps the 401k. Maybe you buy her out of your business, or the house could get sold. But unless you have a valid prenuptial agreement or an ironclad legal argument that something is separate, the court is going to default to splitting it 50-50. So what are some common traps that men fall into? Let's talk strategy and what to watch out for. Trap number one, thinking it's her debt if it was acquired during the marriage in her name. It still could be considered community debt. Yes, this includes credit cards you didn't even know about. Trap number two, failing to track separate property. If you had assets before marriage, you must be able to trace them. Lost records mean lost arguments. Documentation is everything. Trap number three, commingling funds. Deposit your separate inheritance in a joint bank account. That money may now be presumed to be community property. Buy a home with both names on title, even if the down payment was yours, that could create a reimbursable claim. Or worse, convert the entire asset. Trap four, ignoring business valuations. If you're a business owner, the value of your business gained during marriage is likely community asset. You might owe her half, even if she never touched it. Next, what about the house? The family residence is usually the most emotionally and financially significant asset. If it was bought during the marriage, it's community property, even if only one person's name is on the title. If you bought it before marriage but paid down the mortgage with marital income, you may owe your spouse a portion of the equity increase under something called the Moore-Marsden rule. Judges will look at when it was purchased, where the down down payment came from, who paid the mortgage, whether community funds were used for improvements, and in many cases, one spouse keeps the home, the other gets a buyout or offset, but in high conflict cases, or if neither party can afford it, the house is sold and proceeds are split. How do you protect yourself from these laws? Here's what you can do now to protect your future. Start organizing your records, bank statements, tax returns, deeds, loan documents, retirement account summaries. The cleaner your paper trail, the stronger your case. Identify the date of separation. This is a legal trigger that stops the clock on the marital economic community. Be clear, consistent, and document it. Get an early legal strategy. Don't wait until after discovery is over to figure out what matters. At Real Fathers Rights, we evaluate your full financial picture up front. If you own a business, get a valuation strategy. Don't let her handpick an appraiser who will inflate the value and claim half. We've seen it. We've stopped it. Stay off the financial radar. No big transfers, no closing accounts, no suspicious behavior. That can backfire, and it's not worth it. Final thoughts on California community property? Here's the bottom line. In California, what's yours is hers. If earned during the marriage, unless you know the law, have the right documents, and the right legal strategy, you could walk out of divorce court with far less than you deserve. If you're a man in California trying to protect what you've worked for, you need more than just basic legal advice. You need an advocate who understands how family law and the financial reality work together. Click the link in the description to schedule a free case evaluation with Real Fathers Rights. We know the playbook, we've seen every trick, and we're ready to fight for what's fair. Thanks for watching The Fathers Rights Attorney, and if you enjoyed this video, like it, subscribe to our channel, and drop a comment if you have any questions about community property or your case in general. We'll see you guys in the next video.